Good morning, everybody. Welcome to our latest Employment HR Improve webinar, which is onboarding. I'm just waiting for the numbers to come up slightly at the moment because I know that everyone joins right at the last minute. So I just thought I'd welcome everyone and just to assure everybody that you will get a copy of the slides today. So they will come to you. Also, we are recording today. In the course of today, if you have got any questions, which I imagine you will have, we would encourage as many questions as possible. There is a Q&A function, so if you use the Q&A rather than the chat function, that ensures that we get the questions. So for anyone just joining us at the moment, the numbers are going up slowly. We will be sending out a copy of the slides from today, so you don't have to worry too much about making too many notes. So those will be going out, and we'll also be recording as well the session today. And for anyone who has got any questions, if you put those in the Q&A function rather than the chat function, it just means it's easier for us to pick those questions up this morning. And the plan is that we do, say, an hour or so talking through the legal issues, and then we will have hopefully about 15 minutes at the end. But what we'll try and do in the course of today, rather than if there's a question that's coming up in the particular section we're about to cover, we'll try and cover it rather than just leaving it to the end, because that makes more sense. So just I would encourage you to put your questions and answers in as we go along, because we don't want to miss any of your questions. But if we don't get around to all of them, I don't want to promise that we will answer all those questions, but if we don't, we will try and follow up, because obviously we have only got an hour and 15 minutes this morning if we get loads. But I would encourage you to use the Q&A function, because last week when we were doing a very technical topic which was about immigration, and I know Rory's going to cover some of that today, but I think some of those more tricky questions probably were not answered, not asked in the Q&A function, but feel free to ask those questions today. So we'll make a start, because I think the numbers have gone up fairly sharpish now. So just to introduce myself, I'm Emma Morgan. I'm a partner in the Employment and Immigration team in Manchester, and I'm joined by Rory Stone, who's an associate in Nottingham, who's also in my immigration team and is also an employment lawyer. I've also got Charis with me, who's an associate in our Nottingham team as well, who's an employment lawyer, and Antonia, as ever, who's our professional support lawyer and answer of all difficult questions. So thank you, Antonia, for coming along today to help us, particularly with the tricky issues in the Q&A function. So we've got an hour and 15 minutes, and as I say, the slides will be sent out today if you use the Q&A function rather than the chat function to ask those questions. So what we're going to try and do is cover as much as we can in terms of recruitment today, and we're going to cover off the immigration angles as well, because obviously we appreciate difficult times in the economy at the moment. Getting the right people is a challenge. It's as much as you attracting the candidates to your business as you are attracting the best candidates, in a sense. So you've got to sell your businesses and ensure that actually your recruitment processes are top notch and actually express the values and the cultures of your business. So in terms of what we're going to cover off today, we're going to talk about what to be aware of when recruiting, so the legalities and so on. I'm going to be covering that, as well as ways of improving the recruitment process. And that is probably the most driest bit, I think, of the session. So I'll try and make it as interesting as possible, because obviously I appreciate you just don't want me telling you what the law is all the time. So we'll talk about that in a practical sense, and then we'll move on to Rory covering permission to work in the UK, so the immigration angles, because that's massive for a lot of employers at the moment where we're struggling to get the skill base into the UK. We will also cover off immigration hurdles and long-term solutions, and obviously, you know, magic away a solution for us all, but we'll do that as much as we can anyway. And then Charis has got the tricky bit at the end, where she's going to talk about the tricky issues and also what lies ahead in the future, and then obviously we'll have the questions. So if we just move along to the first slide. So what to be aware of when we're recruiting? So, well, the biggest thing I think we probably all think about when we're recruiting, as well as obviously getting the best talent, is actually avoiding any allegations of discrimination. And obviously the protected characteristics cover everything from gender, race, religion, pregnancy, I could name them all. Disability is a big one as well. So we need to make sure when we are recruiting that basically we comply with the law as best as we're able to, and obviously dependent on the resources of the business. So the particular provisions of the Equality Act in particular talk about an employer must not discriminate against or victimize a person in the arrangements that they make for deciding to whom to offer employment, or as to the terms on which employment is offered or by not offering employment. And that in itself is quite a lot to cover in itself, isn't it, in terms of discrimination. So we talk about the arrangements that by which we offer a job, and that covers things like your job advert, your job spec, the application process, the interview process. So thinking about things like where the location of your interview takes place, the timing of that interview. So for example, if you specified that interviews were in the evening, that may well cause problems for individuals who've got childcare responsibilities. And statistically, it's still the case that women carry out the majority of childcare, and at the moment that could potentially be therefore discriminatory. Obviously, things like access to your building, so the location of where you have the interview in itself could cause issues for individuals who may have access or mobility issues. One of the things we've looked at most recently as a firm when I'm doing events is also doing some form of video about accessibility into the actual office. So if we're holding an event in person, actually a video just showing you how you come into the building, how you use the lifts and things like that to make the process as easy as possible. And that was in response to some feedback we had from on the neurodiversity roundtable that we recently did. So thinking about the arrangements, so the basic and the practicalities about how you offer the opportunity to apply for a job, or when you have facility or provide the facilities for an interview, for example. Also on the terms of employment that's offered. So when we think about the terms that are offered, obviously we'll think about payment. So in terms of ensuring it's equal pay, ensuring we comply with things like the national minimum wage regulations. When we're looking at holiday pay and provision, part-time workers, these all should be sort of second-hand to most of you, thinking about part-time workers and the pro-ratering of holiday entitlements and so on. Even things when it comes down to the place of work. So that's quite a hot topic at the moment in terms of where you offer employment. So are you looking at office-based employment? Are you looking at hybrid arrangements? Are you looking at remote working? And in itself, the actual form of hybrid working and that requirement to come into the office may have its challenges for some. And obviously candidates themselves actually might have an expectation of, at the very least, some form of hybrid working which will allow them to work from home. But you need to think about all these things to ensure that you aren't exposing yourself to potentially claims of discrimination. And even in itself, although you haven't actually enforced that arrangement or that term, the very fact of having something that may be discriminatory can in itself cause you issues or be challenged on. So it's really important that you think about all these things when you're going through recruitment processes. And obviously failing to offer employment to an individual, I know Charis is going to talk about this a bit later in terms of tricky issues, but obviously telling someone they've been unsuccessful in their application for a role in itself, whether it's the shortlisting process or whether it's much further along the line in terms of the interview, that in itself, the way you provide that feedback, the way you deal with that in itself cannot be and should not be discriminatory. So moving on to liability in itself, obviously we talk a lot about the Equality Act and discrimination, and obviously in the way that you offer employment or the decisions that you make, if you discriminate, commonly you'd expect the employer to be responsible for that, but the employees themselves, by doing those actions, can be personally liable. Some of you may be aware obviously of claimants being respondents being personally named on a claim form in the tribunal. So individuals themselves that make those decisions in the employment process can be personally liable, and they in turn therefore can make the employer vicariously liable for their actions. But on top of that, you've also got, if you instruct a recruitment agency or a consultant or a headhunter to find recruits for you for a particular role, the way in which they act, if it can be established actually that they have acted on your instructions, they can also be liable and ensure that you are vicariously liable for their actions as well. Adverts themselves as well can mean that the recruitment agent is held liable. There is also this issue around principal and agent and to what extent you have instructed them to do things. But fundamentally, if you are instructing or you're outsourcing that process to another organisation to do, you need to be confident about the way that they are doing it and selling that role and the terms that are being offered, so that you as the employer are not responsible for their actions. So on top of that, you've also got data protection issues, and I know we often talk about data protection because it comes up a lot in the context of employment, and obviously it's important that your privacy notice, so the way in which the business uses people's personal data, whether it's candidates or employees, is managed properly, and the individuals are aware what's going to be done with that. Because when a candidate provides you with their data and applies for a role with you, you are potentially going to be processing their data, whether that's personal data or also sensitive personal data, if in particular you're asking for medical information. You may also, as part of the process, be doing some form of diversity monitoring as well. Obviously, that'd be a separate part of the process, but you need to be aware of all the data protection issues that come with it, because fundamentally you may well be retaining personal data. Even if that individual is unsuccessful, it may be that you've agreed to hold that data for future roles. That's not unusual. So thinking about how you hold that data, how long you hold it for, what you actually hold, and what you can do with that data is all going to be part of the process. And ultimately, you need to make sure that you're complying with not only data protection legislation, but also any kind of discrimination legislation, and more importantly, the Equality Act. So moving on to the next slide. So in terms of improving your recruitment processes, this is really where it's really important for you as a business to think about your brand and your reputation, because fundamentally this is all part of you as a business. When you're attracting candidates and you're asking them to apply for roles with you, you want to make sure that your recruitment process is second to none, because fundamentally if you get it wrong, you could find yourself on the end of social media or some form of some form of negative feedback, which is not going to reflect well on the business. You probably remember a few years ago, an individual had applied for a role, went through an interview process, felt like she was being totally grilled by the business, and actually she then posted on social media how she didn't want to even consider working for that business because of the way they treated her in that process. So it's really important that our recruitment process is reflective of our culture and our values and everything about the business, so that we attract the right candidates and get the right people. So it's really important that you review recruitment processes and policies and procedures and make sure that you continue to do that. It's not a one-off thing. It's got to be fit for purpose for you as a business, and also to comply with legislation, so that those involved in the process act consistently, that if something does go wrong and actually a claim is brought against the business, that you can defend that claim. And also that actually that process and the people within that process reflect the values of the business and the culture, and thereby reducing the chances of any kind of discrimination claim being brought against the business. And obviously, as part of that, you're going to need to train your employees on the recruitment process. You can't just expect them to know what to do and how to do it and how to follow it. There are lots of things within that process that could cause you issues, like, for example, the decision-making process or any notes that are made in the process. Does that manager understand what questions can be asked? Have they seen the job specs? Are they the best person to be interviewing for that process? Do we need an interview for it? There are lots of questions that need to be thought about, because fundamentally, people making decisions within that process, whether it's selection or shortlisting, or whether it's interview or marking some kind of written exercise, there is going to be some form of, you would expect human interaction and potentially subjectivity there, and we want to make it as objective as possible and ensure that people avoid things like unconscious bias, avoid stereotyping, making assumptions about individuals. And as part of your training, you may do some form of unconscious bias training as well, because you want to make sure that you are getting the best candidates, but also the individuals carrying out that process are reflective of the values and cultures of your business, and then can make the right decisions in terms of recruitment. One thing to always bear in mind is the Equality and Human Rights Commission statutory code of practice on employment and recruitment, because in itself, although it is a statutory code and can be used as part of any tribunal decisions, or as candidates who are challenging this process or challenging any decisions you've made, it could be quoted at you in tribunal. And the things that they talk about are ensuring that you have as wide a pool of candidates as possible, and that will be part of your sort of advertising process and considering where you advertise and how you advertise, that you have a clear and objective selection process, so everyone is clear how the process is going to be worked and how fundamentally you will get to the point of hopefully having that candidate that you have selected, and that candidate being the right candidate, avoiding stereotypical assumptions and ensuring that candidates are all treated fairly. And again, it comes back to your training and making sure that those involved in the process are fully briefed and understand what they're being asked to do and understand what your requisite procedures for doing it are. And I think one of the other things that we've talked about as well, I've mentioned previously, is keeping records of the recruitment process and reasons for the decisions made, because fundamentally those could end up in tribunal. And we always say, you know, if you put anything in email, you need to be clear that you could be happy to say that in tribunal. In the same way with any recruitment process, if you're making notes as part of the interview and selection process, you must be prepared to disclose those and be happy with what you're writing down, that they are that's consistent with the values and brands, and actually that is something that you could stand by if you were asked about it in tribunal. And that is really, really important, because fundamentally in all of this process you need to be thinking about actually getting the right person for the job. So moving on to the next slide on improving recruitment processes. So when you're looking at your vacancy, what is it that you need and how can it be performed? So are we replacing someone who's already left? Or is it a totally new role? Is the business expanding so much that actually we need something new? We've not had it before. Or are they going to be one of many people doing that particular role? And obviously the vacancy itself is really important to understand actually what you need for the business. And it may be you have had somebody previously in the role, but actually what you want is something slightly different. And it's got to be about the role rather than the individual. So have a job description, a detailed job description and a specification. So draw it up in full, get the input from the managers, from HR, from senior leaders within the business. And the danger is that you always go back to what you had before and don't think actually, what do we need for the future of the business? Is that actually fit for purpose? And focus on the business need, not the stereotypical requirements, and use the appropriate job titles, because just because you've had it before and we've always used this before doesn't necessarily mean that's what's fit for the business going forward. Your focus should be on skills-based hiring to ensure you get the right people that can adapt to the business, people that can learn new skills as well, rather than going on what you've always done before. I think we always hear these terms of recruiting in your own image, but fundamentally you want to make sure that your business is diverse, the employees within it are diverse, and they represent the community and they give you the diverse thinking that you need for the future proofing of your business, because that's what's going to help and drive and make it better than it is now, for it to be innovative. So consider where and how you're going to advertise. So widen the talent pool beyond just the location that you're in now potentially, or what you've done before. You know, fundamentally think, well, do I need somebody who's office based? Or can we have someone based remotely somewhere? Do they need to be in the UK? Do they need to be abroad? Or can they be abroad? Those are the questions you need to be asking. They do have obviously issues attached to them that you need to think about, but actually what are you trying to bring into the business? But don't always think about what you've done before, because geographical boundaries themselves have sort of to some extent disappeared because of COVID. People have assumed that they can work abroad, but there are obviously restrictions around that. But the whole idea of you being office based now is probably moved very far away from what it was before. I mean, fundamentally, we all thought we had to be in the office 5 days a week, 4 days a week, 3 days a week, whatever the work arrangement was. But the expectations of the candidates and the businesses are now different. I know there has been a move back into the office, but there will be an expectation with lots of candidates that there is some form of hybrid working at the very least now. And as part of the interview process, be prepared to discuss the culture and the working practices and the values of the business, because this is much as a selling process about the business. It's not just about you grilling the candidate. It's about your brand and your reputation, and also about the business itself, so that you want to attract the right people. And always be prepared to make reasonable adjustments. So when you're looking at that vacancy, thinking, does it need to be full-time? Could there be a job share arrangement? And as I say, what about location? What about hours? Can we be more flexible now? Has COVID taught us actually that we don't need that standard 9 till 5 in the office role anymore? We can be a lot more flexible, and that might well help with a business that's more international in terms of variable hours, but there may well be still a need for them to be in those core hours and to be in a particular location. It's all about thinking about that and justifying actually what you need for the role. So moving on to the last slide in terms of improving the recruitment process. So you've gone through the initial process and you've advertised and you've thought very carefully about what the role needs to be. You're now going to have to decide on how to shortlist and select in terms of the process itself. And that in itself, as I say, you've always got to have at the back of your mind, actually, are we doing the right thing in terms of ensuring that we get the best selection of candidates, that we're not causing ourselves in any issues and disadvantaging anyone with protected characteristics. So we need to think very carefully about that process. And again, our managers need to be kept trained and updated on what those processes are. And actually, the shortlisting and selection process may well be different for different roles within the business. Not every role is the same. You'd expect that to be the case. What you might decide to do for one role, whether it's an assessment centre or whether it's psychometric testing, might not be necessary for a different role. So it's not the case that you have to have the same thing for everything else, but certainly you need to think about carefully what you apply in and ensure that you aren't disadvantaging any particular candidates who may well be put off by the process as well. And obviously, when you're making an offer in employment, obviously thinking about, is it conditional? Fundamentally, there may well be certain conditions attached to the role before it can be accepted. One of those is the right to work, which Rory will come on to talk about, because obviously you want to check that before you formally effectively enter into that contract with that individual. But there might also be a requirement for qualifications. The individual has said to you, I have these qualifications are what's needed for the role. So actually, can they show us that they can demonstrate that they have those qualifications? Similarly, you may ask for information once selected on as part of a medical. Again, that's not going to be justified for every role. It's not going to be appropriate for every role, but there may be certain reasons why you'd need to ask for a medical report, but that shouldn't be done until at least the selection stage. And also asking about medical information is prohibited in a lot of cases. So it may be that you wouldn't ask for it till later in the process anyway. But again, that in itself can cause you issues if you're asking for that information and you're not allowed to do so. There may well be pre-employment background checks that you need to do for a role where you're working with vulnerable adults or children. So you have your DBS checks, and that would be a requirement for the role because that individual couldn't start unless that check has come back sufficiently. I know that in itself is a complicated area, so I'm not going to profess to go into that in any detail today, other than to say you need to think very carefully about why you ask for that information, because there obviously is the Rehabilitation of Offenders Act. So if you're asking for criminal record checks, you need to think about why you're asking for them, because obviously it means that certain convictions are spent, and if they're spent, they won't show up on it. So if you need to know about spent convictions, they're generally going to be in roles which require you to work with vulnerable adults and children. But obviously that's going to depend on the particular role you're advertising for. But obviously that would be part of the pre-employment background checks, and the individual couldn't start the role until those checks have been done, and the contract won't be entered into until all those things have been covered off. Also, references. I know these days references tend to be pretty short and very factual, because obviously anything that you ask for which could cause you some issues in terms of a discrimination claim, like even asking for absence records, obviously can cause you issues in terms of disability claims. So often references are kept to be very factual things to confirm the individual has worked previously for the employer. You may ask about things like disciplinary records and so on, because they are obviously something you'd want to know about, but you just need to be very careful about what information you ask for as part of a reference, because you don't want to be challenged or victimizing a particular candidate. And the outgoing employer could have victimized a candidate by providing that reference in a sense as well. So even if you're asked about an employee that's leaving, you need to think very carefully about the information that you provide, because it can be a minefield. One thing the European Commission of Human Rights one thing they talk about in terms of the code is recommending that you don't circulate references to members of the selection panel until after selection, because obviously what you don't want to be doing is giving information which might have an impact on their eventual decision making and might be something that is then challenged or forms the basis of a discrimination claim later. But obviously, in terms of any recruitment process you go through, you're going to look at the size, the administrative resources of the business. So that will dictate how you go through your process, whether it's selection assessment centres. Obviously, you might have those as part of a graduate programme because you're having so many candidates and you want to see as many as you can in a day. But the tests themselves, obviously, in the interview process will depend on the role that you particularly are advertising for. But obviously always remember the protected characteristics and have a think about at each stage of the process whether any of those candidates are going to be disadvantaged with those protected characteristics, and ensure that you make adjustments so that those things are not going to have a detrimental impact on your recruitment process, but also potentially lead to claims arising from the process itself. And I appreciate I've covered a lot of ground there. And I don't know whether there's any questions. Sorry, Anthony.
Yeah, actually, there are a few that have come in, which kind of fit quite nicely here, if that's all right with you, Emma. So a couple actually just on references, which probably makes sense to pick up first. So one was, our references still mandatory, because the particular person said they often have difficulty getting a response, and references aren't mandatory.
No.
And actually, I suspect some employers may well not want to give a
Yeah.
reference, because if they say anything that's misleading, they can then be liable for that. So I think
that's a class of victimization claim, isn't it? Once they're leaving, you say too much in a reference.
yeah,
And it's really sad, isn't it? Because, you know, what should just be a factual based question ideally is something that employers don't feel they want to do anymore in case it comes back to bite them.
yeah. So there isn't anything, you can't force somebody to provide a reference. And actually, there's another question: is it okay to ask the reason for leaving in a reference? And yes, again, you can, but whether you will actually ever get that response, it, you know, references have really not become that useful anymore, have
No, because
they?
I think employers are, I think almost if you give too much information, it could come back on you. And then if you don't give any, obviously you can be badgered, but you don't have to. There's no
No.
obligation to do that.
Yeah.
So it's a bit of a difficult
Yeah.
area, really.
And then just two other questions we've had. So one was about giving feedback to an unsuccessful candidate. Can you say that they're not the right fit for the team? And I mean, my view is that's quite a difficult message, because it's quite subjective, and obviously you run the risk that then somebody says, well, that's discriminatory because actually I'm not the right fit because of X protected characteristic. So my feeling is, if you can, it's much better to give objective reasons why you're not offering the job. Would you? Yeah.
Agreed. I think the problem with it is that fit, that point, you're not the right fit. And I go back to this point about people saying you recruit in your own image. And I think the fear with saying, well, you're not the right fit, is that you aren't in the image of the rest of the team. And that's when you get into that perpetuation of always having the same type of person within your team.
Yeah.
And you might not always, I think that's where that unconscious bias comes in, you know, really kept making you think twice about the decisions that you're making, and actually trying to move away from always doing the same thing. You might not even recognize you're doing it, but I think that fit, I think we did use that word for quite a long time, and actually I think its connotations are quite negative now.
Yeah. And just one quick one on GDPR and retention of information for candidates who aren't successful. And I think it is worth keeping that information for perhaps 6 months following the application process, in case there is any challenge as to why the job hasn't been offered to them. But beyond that, you probably don't have a legitimate reason for keeping it. Would you agree with that?
Yeah, I think that's probably right. I think it's useful, I suppose, if you've, particularly where you might have short-term contracts or something like that, to keep a bank of people. But I suppose the problem with it is, the longer you keep it, how up to date is that information? Because you've always got to think about making sure the information is up to date. And I suppose if you're very diligent, you might well write to the candidate or the former candidate who was unsuccessful and say, are you still happy to be on our database? But obviously that in itself is a resourcing thing, isn't it? You've got to keep on top of that data in itself. So I think it's good and it's useful, particularly where, you know, you might have recruitment again in the same role coming up, to keep those candidates on board, particularly where, I mean, recently we had interviewed so many good candidates, and I said, you know, we should definitely keep these people on record because they all are brilliant. So I can definitely see the merit of it, but in itself it does give you another data protection hurdle.
Yeah, and if you are going to keep it for longer or for those purposes, then you need to make the candidates aware of that before they provide their information. So you need to have your applicant privacy notice to reflect it. Great. Okay, I'll come on to some more questions later. Thank you.
Well, I think I'm handing over to Rory now for your section on permission to work in the UK.
You are. Thank you, Emma, and very good morning to everyone. So if we can move the slide on, please. So yeah, the first here, I thought I'd just start by giving a general overview really of the immigration scene in the UK at the moment. And certainly here at Shoesmiths, we've seen an increase in sponsor license applications amongst our client base, really starting in 2022, continuing now into 2023. And that fits with the national trend. Recently, the Home Office released their 2022 statistics, and that showed that in January last year, there was 57,000 businesses that had sponsor licenses. Yet by the end of that year, the end of 2022, 83,000 were holding sponsor licenses. So that's a huge jump in just 1 year alone. So why are we seeing that increase? Well, the full force of Brexit is now being felt. The changing geopolitical climate hasn't really helped either. And what that's all done is uncovered this huge skills gap which we've got in the UK. In some sectors, I mean, it's normally spoken about in kind of the tech sector, it's becoming almost impossible to recruit the talent needed to keep up with the business demand. If we take tech as an example, it's been quite widely reported that the sector is expected to bring in just shy of, I think it's about 125 billion to the UK economy in the next few years. But to achieve that, they're going to need to fill 675,000 more jobs. And that's as well as retaining the millions, I think it's between 1.5, 1.75 million people already employed within it. So the scale of the task is quite large, particularly if you're seeking to rely just on the UK talent pool. And I think that's why the sponsor license is so important. It obviously allows businesses to recruit from outside the UK or to recruit visa holders who are already in the UK but working for a competitor. So of the visa routes, by far the most popular, and you can see it there on the screen, is the skilled worker route, accounting for 61% of all work-related applications last year. So for those unfamiliar with this route, it enables businesses to recruit people in certain job roles, provided that that job position meets the skill and the salary, a certain skill and certain salary threshold. So it's labelled as a skilled job. So that's kind of the most used route that we've seen. If we can move on to the next slide, please, which is going to kind of cover the immigration hurdles, I suppose. As I say, lots of businesses at the minute weighing up whether they need to get a sponsor license and what that entails. I think it's really important just to cover off these key points here. So firstly, the time that it takes to obtain a sponsor license can be quite lengthy. The application currently takes up to 8 weeks to be decided by the Home Office. Skilled worker visa applications themselves can take between 5 working days and 8 weeks, depending on the route that they are submitted under. For example, there are priority services available in some circumstances that will obviously speed up the decision time, but they do cost more to utilise and they can be quite competitive to get onto. Secondly, recruiting non-British and Irish nationals is expensive business. So as an example, to assign a certificate of sponsorship, which has to be done each time a visa application is made, will cost £199. And then the business is also liable to pay £1,000 per year that the worker is being sponsored for. So that's by way of an immigration skills charge. Now, a lot of the time we get asked, can we pass that cost on to the applicant? You can pass some costs on to the applicant, but not the immigration skills charge or the certificate assignment fee. These are costs that cannot be passed on to the applicant as they're a business levy. It's the cost of the business for recruiting from outside of the UK talent pool. In terms of the applicant cost, they'll be expected to pay the immigration health surcharge, or the NHS fee as it's commonly known. That's currently set at £624 per person per year. And then you've got the visa application fee itself, which can range from £700 up to about £1,400 per person, again, depending on the circumstances and the specific visa route. There's then additional costs such as visa centre fees. You might have to have documents translated. If people need to sit English language tests to demonstrate their English language ability. There's going to be TB tests in certain countries. So it's really easy to see how these costs can spiral and go into the tens of thousands of pounds, particularly if the sponsored worker's got dependents, a couple of children, a partner coming across. It can really be expensive business. I think the most important one on this list, though, and it's probably the one that we don't really talk about a lot, is the sponsorship duties. So once a business actually obtains a sponsor license and starts employing sponsored workers, you need to ensure that they're meeting the reporting and record keeping obligations. That's two separate things, reporting and record keeping, and they're set out by the Home Office. So this entails retaining various documents such as contracts of employment, dates that the applicant enters the UK, their passport details, residential addresses. All of those types of things need to be retained for the duration of the sponsored worker's employment. And that's because if a compliance officer visits from the Home Office, the business will be expected to show that they have those details readily to hand and have robust processes in place for retaining those documents. So it's really on the business to show that they are monitoring their own sponsored workers and taking responsibility for those activities whilst they're in the UK. Businesses have also got to report certain things about the sponsored worker to the Home Office via the SMS portal. And I think really speaking to our clients over the last couple of months, this is the biggest challenge that they're seeing, because they're expected to report things such as unauthorised absences, changes in job titles, changes in salaries, anything that might impact that job that they are being sponsored to do. And what we see is line managers or people in the business promote sponsored workers. They might not know too much about the fact that they're a sponsored worker, but they don't then report that to maybe the HR team, the onboarding team, mobility, whoever's responsible for those sponsorship duties. So it's just making sure that within the business, every department is aligned so that those changes are being reported properly in line with the Home Office obligations that are set out. And I think that kind of brings me on quite nicely to the point there about resourcing. So you can see that holding a sponsor license comes with quite a lot of obligations. There's a lot of administrative responsibility attached to it. So before applying, businesses should really consider how big their recruitment or HR team is. Who is going to actually manage this process? Is there a dedicated mobility team that can take that on? Who does the onboarding and the induction process? Who's responsible for the sponsored worker within the business? Is it going to be that line manager? Is it going to be a member of HR? Is it perhaps a senior individual? And I think the answers to those questions will be governed by how big the business is and who is really involved in the day-to-day operations and management of that individual. There's also obviously a discrimination risk. So we want to really point out that when recruiting businesses can't reject an application or refuse to give somebody the job based on cost alone. So for example, if one applicant requires sponsorship and the other does not because they're a British and Irish national, then you've got to remove the cost of sponsoring applicant one from the decision-making process. It could be viewed as discriminatory if you pick applicant 2 based on the sponsorship cost on the basis that applicant 2 is just a different nationality. So instead, businesses have really got to look at their policies on sponsorship, focus on all the things that Emma's spoken about, the qualifications, the experience, the suitability for the role and the skills that are required for actually within the business itself. That cost alone argument is just not going to stack up as a defence in a discrimination case. And finally there, we've touched on it, practical issues. So EU nationals are required to undertake an English language test now under the skilled worker route if they don't possess a degree that is taught in English. That can come with its own issues. The cost, obviously, but the actual test alone isn't widely offered throughout Europe. In France, for example, I think there's only 3 or 4 test centres. So applicants are having to travel quite far to sit this test just to prove their English language ability before making the application. So plenty of hurdles there to consider when it comes to making the application. So if we could just move on, please, to the final slide from me. And it's, what do we think is going to happen moving forward? Well, this government have insisted that the UK workforce must become self-sufficient rather than relying on the EU and overseas labour. So I suppose, what does that mean? Well, it means instead of looking to the overseas talent, the government would really like businesses to consider longer term aims, such as investing in recruitment. And I'm not naive enough to suggest that the UK government are pushing their problems onto the business community. But I suppose what they want to see businesses investing in local colleges, schools, maybe investing in creating graduate programs, startup programs, really bringing in talent to the business from a younger age, building those collaborations with local educational institutions, maybe pool sharing with other businesses in the community. I think businesses are also being encouraged to make roles more appealing to domestic workers as well. A lot's been said about pay recently, particularly at the tail end of 2022, but I think it's also looking at the benefits that are on offer, and training and upskilling opportunities. It's sometimes not as easy as simply offering more pay. It's about looking what certain workers want, both in the medium and the long term. And I think more and more we're seeing that that's linked to development and career opportunities. So in terms of pure immigration solutions, I suppose a less onerous and costly unsponsored route to cover the lower skilled workers would certainly assist businesses and ease the pressure, but I'm just not sure that that's going to happen, unfortunately. We do expect there to be some amendments and changes to the shortage occupation list, and that will make it easier for some job roles to be sponsored. But I think that's probably not going to come this year. It'll probably be, if anything, towards October this year, but more likely into 2024. So I think that's a whistle-stop tour of immigration considerations. I don't know if there's any questions there. There normally are.
There normally are, Rory. Yes, you have them flooding in. So there have been a couple actually around that point you made around the discrimination risk and the cost alone isn't enough.
Absolutely.
So a couple of questions have asked, well, what if we don't actually have a sponsorship license and it's not feasible to get one? Is that a reason why in that scenario you said you could reject one candidate above the other?
Yes, I think it's treading carefully at this point, because it's linked to administrative burden as well. You can show that if your business simply doesn't have the resources available to manage a sponsor license, to obtain that sponsor license, and that can act as a defence. I'm not suggesting that that could be the sole defence, but the tribunals will adopt a pragmatic view on that. I think what they're trying to avoid is people, sort of avoiding those tens of thousands of pounds that we've spoken about, and just simply hiring a domestic worker to save in costs. But yes, certainly that administrative burden, do an analysis, have a look at how that's going to work in practice, and certainly use that as a defence if needs be.
I don't think we've actually had any cases yet that I know of where they've actually had a case reported in the tribunal about this, about why an employer hasn't actually got a license. The thing with it is we are still in the early days after the removal of the resident labour market, and actually we did have a cap for a long time, which made it more difficult for employers to recruit from overseas. So I suppose the one thing that the government's made it easier to recruit, but equally there's no obligation on you to get a sponsorship license. But if you decide not to get one and you're challenged on that decision by refusing sponsorship or considering it, then you just need to be robust in terms of actually what your business case for going back to that individual and rebutting that challenge is, because it is a decent, and as Rory said, it is a big outlay in terms of cost, but also from resourcing point of view, the Home Office expects a lot. So, in itself, it is a big thing to do, I think, as a business.
And I suspect as long as you can evidence that you've thought about it and you've got your reasons why you haven't put it in place, that's going to be key.
Yeah.
And just linking, I guess, with that is somebody's asked the question, can we actually put in our, almost when we're advertising roles, that candidates have to have the right to work because we don't have a sponsorship license? Is that a step you think could be taken?
Do you want to say that one, Emma, or shall I?
I think the thing
big question, that one.
I think there's two things, because everyone has to provide documentary evidence that they've got the right to work. And when I say documentary, it may be a digital check. But I think there was a question around British passport holders as well, because you can still do a physical check. You can either use I need to get this right around the IDSP to do it, which would be a digital way of doing it, I suppose. But you can use an IDSP, or you can still do your physical checks for your Irish and British passport holders. And it's a digital check through the online platform for anyone who has any other things like a settled or pre-settled status, so European nationals, for example. So everyone, regardless of nationality, is subject to a right to work check. The secondary point about the license is that you may well say on your advert that you don't have a license and that you're not able to offer sponsorship. And that might be a decision that you've taken as a business because of the number of applications you get. Or you may even say, we have a license, but this role isn't suitable for sponsorship because it's not of the sufficient skill. It depends on what you want to do in your advert, because in itself, by putting something like that on there, you may well be opening yourself up for criticism, but equally you might be managing expectations of candidates at the same time. So
But
I think
also potentially missing out on candidates as well.
Yeah.
Because you might not have a sponsorship license, but for the right candidate, for the right role, it might change what the business thinks about it. So
yeah. And we have had clients before that have asked us about putting something on their adverts because they get such a high level of recruitment activity and high level of applicants, and they can't sponsor, even if because they have a license, for example, but they can't sponsor the role because it's not of a sufficient skill level, because it's still got to be A level, subject to some quirks, I suppose, in the skill shortage list. But generally speaking, you're looking at a role which requires at least A levels. So that means that there are a whole load of roles that you can't sponsor at all in the UK.
cool. Okay.
Have we covered them all off, do you think, Antonia?
I think we've covered most of them. There is one actually that's just come in, that if you have a sponsor license and you've recruited candidates via the skilled worker route, but you no longer have funds to support new candidates, how can you manage it?
I think it would depend on it depends what we mean by funds, I suppose. As in the I think that's probably a bit more to that question that we need to understand to answer that one. But yeah, as I said, the only obligations that the business will be under will be the immigration skills charge and that assignment of the certificate. I think there's lots of businesses out there who are very generous and do offer support to applicants as well, and make those payments and maybe offer them loans or clawback agreements. But yeah, I think it would depend really on that situation and what the funds mean.
Perfect.
Because I think there's a question about consistency with all of this. This is why one of the things we always recommend is that when you get a license as an employee, you think about your policy. So you think, actually, because it's some business, they may well say, well, actually, we'll only sponsor at this level and above, or we'll only sponsor in these specific roles because there is a recruitment need to do that. Because it may be that we'll get lots and lots of applicants for different roles that can be sponsored, but actually we wouldn't offer sponsorship because of the cost, resourcing and things that go with it. Because it is, the more and more you sponsor, the more reporting obligations and more administration and that go with it, the risk attached with it goes up. But you've obviously then got to think carefully about that business decision and be able to robustly go back if you get any challenges on it. But I do think it's important, because the problem is if you start off by saying we're going to sponsor everybody, you'll soon realize the cost mounts up, and actually you're sponsoring it, and the administrative burden and the reporting burden and the fact that you have to train the people within the organization to understand the risks attached to it mean that it becomes more costly and takes up more management time and things like that. So it is a really great tool for recruitment, but equally you've got to manage the level of risk attached to it at the same time.
Good. I think on that note, then I'm passing over to
Charis. There you go, Charis.
I've left you a whole 10 minutes to rattle through the most complicated part.
So we're now going to take a look at the types of challenges we can often see our clients face in this area, and how we would approach them. So the first of these is how to deal with applications from former employees. So if faced with this, it's important to note that there's no special right for former employees to be shortlisted or be given any special treatment above other applicants. And that's the case regardless of how the employee previously exited the business. So on that basis, former employees should be treated the same as every other applicant during the recruitment process. But then there's also the issue of whether an employer can look at a previous employee's historic records during recruitment. And again, we'd say not without considering the wider data protection implications of this. So for example, an employer would need to consider what information has been retained about the former employee, why they've retained the records in the first place, and how long these have been kept after the employee's initial exit. So it's important to bear in mind that the data must not be kept any longer than is necessary for a legitimate purpose. So for that reason, any reference to previous records should be approached with care. And then also on this issue, it's never advisable to have a list of former employees who an employer would not re-employ. And there's a general prohibition on blacklisting of this nature. So particularly if that's because of something like union membership or similar. So it also might lead to a discrimination claim where the reason for naming somebody on the list is because of a protected characteristic. So whilst on the face of it, you might think that such a list is harmless. So for example, noting ex-employees with poor attendance records, but the reason that they had poor attendance might be, so that could be discriminatory because poor attendance might have been because they were off sick due to a disability. So there are just important wider considerations here as well. So overall on that issue, we'd just say it's important that applications from ex-employees are considered on a case-by-case basis. Then next on the slide is giving feedback to unsuccessful applicants, which Emma and Antonia briefly touched on earlier. So it goes without saying that this is best practice and candidates would always prefer to have feedback rather than simply get a rejection, email or call. But it also goes without saying that the feedback should be delivered in a sensitive manner with any negative comments or criticism linked to the requirements of the role or the person's specification. So overall, I think as Emma and Antonia said, feedback should always be capable of being supported objectively. It's also important to remember that any document of this nature detailing feedback, it could end up in a tribunal record and so in the public domain. So it's just about treading carefully with this one. Then next we have using psychometric tests. So that's another topic that we get asked about quite a lot, and these are becoming more and more prevalent within the recruitment process. So the tests usually gauge personality and intelligence or biodata. So they can cause some concerns from a legal viewpoint. But the very first thing to consider is whether the tests are actually necessary and whether they're proportionate to what the business is trying to achieve. So if you only have a small number of candidates, say, then it's likely that another way of testing people might be more helpful and effective. But that being said, if the test is well designed and properly administered, then they can be useful for predicting performance in a particular job kind. So we can see why they are used. But what we would say in relation to them is that the test shouldn't be the only way to assess candidates. And there are a strict set of guidelines from the Equality and Human Rights Commission on their use. Because there are concerns that the test might discriminate against certain individuals, and so an employer should consider what adjustments might need to be offered for some candidates. So that could be, for example, written instructions, extra time, or giving reader assistance as well. So all in all, on this point, we'd just tread carefully when using psychometric testing and just making sure that they're administered properly. So yeah, I guess just ensuring that it's thought about if you're making these tests part of the recruitment process and that adjustments are made if that's necessary. And then next we have the use of AI by applicants. So we're going to speak a little bit more about AI in just a moment, but this is something that's becoming increasingly common, an increasingly common issue for those that are recruiting. So applicants can now utilise programs, for example, ChatGPT, to create and customise CVs and then applications and cover letters. So the benefit of that for applicants is that it saves time and it obviously allows them to apply for more jobs in a shorter time frame, which in itself might not be a problem for businesses because I guess CV and cover letter very rarely shows the true extent of a person's ability to carry out the job anyway. But you might find that there's a less personal touch in the application, and it might explain why you're receiving standard answers in some cases. As I say, we'll come on to talk a little bit more about AI on the next slide. But finally for this slide, so this is the big one. What should you do if you discover that an employee has lied during the recruitment process? So if you make an offer of employment or enter into an employment contract and you later discover that an employee has lied on their CV, or maybe as part of the interview process, you might find that you want to, the information that you find out means that you want to retract the offer, and that's easy enough to do if the lie is discovered promptly. So in that case, a dismissal could be without notice, and that would be justifiable if the dishonesty or if the lie is significant enough to amount to a repudiatory breach. But if it's not significant enough, then it might be dismissal without notice, and most employers would then make a payment in lieu of notice. So if it's done quickly enough, or if the lie is discovered quickly enough, within 2 years, then an employee wouldn't have the requisite service to bring an unfair dismissal claim. But we have seen arguments that the employment contract should be set aside as void from the outset, so due to misrepresentation on the part of the employee. We think this is probably a tricky ask, and the limited authority on the matter suggests that an employment tribunal would be unlikely to uphold that argument. But then, so what to do where the lie is discovered sometime afterwards, so once 2 years has passed. So the situation would be slightly different here. An employer would need to consider several things. So, for example, the impact of the lie, whether it has any effect on the employee's ability to perform their duties, how the lie was discovered, and then so a range of other factors, and again that would just need to be considered on a case-by-case basis. So I think that covers off the tricky issues. If we could just have the next slide, and I'll just go back to talking a bit more about AI. So just in terms of the future, so as I mentioned previously, so AI is just changing the way that the recruitment process works. Employers are also now often using it to sift through application forms. As you can imagine, this saves time and energy. And so some businesses are also using it to search social media for key phrases and strengths. So for example, searching a phrase such as so experience in software engineering or something similar. And some have even started to use AI to auto filter test scores and analyze applications. And so whilst, as I've said, this absolutely does ease the administrative burden on recruitment teams, it's also important to consider whether such an algorithm could amount to a PCP, so a provision, criterion or practice within the meaning of Section 19 of the Equality Act. And if it does, then an applicant could potentially bring a claim of discrimination if they felt that the algorithm was a provision, criterion or practice which prevented them from performing or scoring well at an interview, and then potentially ultimately them being unsuccessful in being offered the job. So when it comes to this topic, ACAS have released a study which has advised that the use of AI in the workplace, and including during the recruitment process, shouldn't replace human line management, because as you might expect, there are concerns that this could result in AI-powered technology, I guess making life-changing decisions about people's lives. And at the end of the day, people still have people problems, and businesses still have a duty of care to consider. So with that in mind, if AI is used, then the best approach is that so training should be given on the algorithms and the potential risks of relying on them. Then this is an obvious point, but algorithms should never be used to mask intentional discrimination. And then arguably the most important point in the report is transparency. So businesses who use algorithms should be transparent about how they're using them. how with candidates and what type of thing that they're actually measuring, and with this transparency, and if they're being administered properly, then this shouldn't be a problem. And then finally, just ACAS have called for an agreed set of standards on the ethical approach to AI. So I think the most up-to-date position now is that on the 29th of March, a policy paper was introduced to introduce regulations on AI and how it can be used in businesses. So the government has welcomed views on this, but I think it very much remains a bit of a watch this space at the moment. And then, yeah, I think that's everything from me. I don't know if you had anything to add on that one, Emma, or...
No, I don't think so. I think I was quite interested on the chat GPT stuff, because obviously it seems like it's going to be an area that candidates might exploit. I think one of the questions that came up, saying someone had said that's why they use application forms, and I suppose the issue, the reason that you might use an application form is you're in control of the information that you're asking for, whereas if you receive a CV from a candidate that was obviously drafted in the format that they wish, that might include information that you need to redact before you go through the process. And I suppose if you've got a CV and you've got these AI products, there is more scope to use that sort of thing to make your CV better. But you know, it depends on whether how far better goes, whether it goes to the point where you're misrepresenting you as a person, and it's information that can't be verified. But you know, it just is a fascinating area, and I know it's impacting a lot of the HR world at the moment, just in terms of policies, procedures, letter writing, you name it. So
yeah, absolutely.
Cool. Well, we still have some questions, so we can finish off just with a few of those for anybody who's able to stay with us. So actually, coming back to one of the tricky issues you were talking about there, Charis, which was re-employing people. So one of the questions is that they've got somebody who has a former employee who has reapplied, but the business don't want to employ them because they left for conduct issues, or there were conduct issues, I should say. And how would we recommend giving the feedback? And I guess my initial thought is, does the former employee know there were conduct issues? Because if no, so the question says there was no formal action taken. Well, was it even raised? Was it a point that there were allegations that were raised and those were investigated, but the individual left before any formal action was taken? I think, and because I think there is a difference, isn't there, between a situation where the employee knew that there were allegations that had been made against them, and that might then be a basis on which you could say, well, in view of the allegations, we don't want to re-employ you. If they're not even aware that those allegations were made or that there were any issues, I think it's more difficult to rely on that and give that feedback. I don't know, Emma, if you've got anything else you wanted to add to that.
I think that's probably right, because I think if there are conduct issues, and those were on the record, then you'd expect to be able to feed back on that basis. If there weren't, I think it comes down to actually looking at the role itself. Is there something about the role and the way that it's what you're requesting in terms of skills, experience, genuine experience, qualifications, which mean that that candidate is objectively not suitable anymore for it? I don't know. It's trying to find something which, whenever you're giving feedback to any candidate, you've got to be able to stand by that feedback, and to be able to, if you're challenged on it, be able to explain why you've made the decision you did. And it's not about the individual, it's more about the role. And if you look at the role, that individual hasn't got the requisite of what we need to move forward in the process. And I think that's the important thing, is to focus on the role rather than the individual.
Yeah. So something we've had, an interesting question, not something we've touched on very much, but about social media checks. So I know that these are becoming more popular, aren't they, with employers, as to kind of, you know, looking at what individuals are doing, Facebook, Instagram. I mean, I can certainly understand looking at LinkedIn. That seems to be fairly obvious, and that's obviously a professional business network. So, but I think employers do look at Facebook and Instagram and that sort of thing. But I think you have to be a little bit careful, because obviously what somebody is entitled to do in their private life shouldn't necessarily have an impact on their professional life, subject to what they do and what the role is and how senior they are, and how much of the reputation of the business could be affected. So I don't think it's possible to have a kind of
blanket
we will always
policy.
do this. Yeah,
No.
exactly.
And I suppose the difficulty with it is that if you search somebody, what do you then do with the information that you find? Because is it then, oh, I don't think I want to employ that person, because you know, it makes it more difficult, doesn't it? Because if you find out something that you think, oh, I don't want to employ them because I've seen that, then it becomes more and more subjective, and it's more about the individual than the role itself. So you know, it's you've got to be careful what you're looking for, I suppose.
Yeah.
No, I know it's done. There's no question that we all look and have a look at who those individuals are, but we just need to be careful with what we do with that information, because in itself it could mean that we're using something which is a protected characteristic and might mean that we're challenged in our decision making. But we'd have to stand by that. What is it that's so bad that means that we're not going to select or take that candidate on?
Yeah. And actually, I think that's a really good point you make, Emma, about knowledge, because one of our other questions was, should we be asking new starters for their medical history to find out if they've got a medical condition that could impact on the job? And what I often used to say to clients is, well, if you don't know, you can't discriminate against somebody. So there are some roles where it's really important to have medical information. So if somebody is going to be in a health and safety critical role, then it's right that you would want to ask about their medical history, because it could be dangerous if they're operating machinery or they're working at height or something. But for other roles, do you really need to know? And sometimes it's better not to know, because if you've got no knowledge, then you can't discriminate against that person.
Yeah, I agree.
On that basis. So again, I wouldn't do it for every role.
And I think the very reason, casting my mind back again, one of the reasons that the disability discrimination legislation was brought in was for a time that what the government was saying is that employers were using things like mental health against employees, and that was why they brought some of the legislation to stop employers asking about it before they started work. Because there's this whole push around, I mean, mental health is massive, and we're in Mental Health Awareness Week, aren't we, at the moment?
Yeah.
And what the government was, I say the government, what the focus at that time was not to effectively treat candidates to their detriment because they had mental health issues. Because why would you necessarily know that individual has got why does it necessarily impact? There will be lots of people who have hidden disabilities and you wouldn't necessarily know, and it never impacts on their job, and why should it? So I think that one of the reasons the legislation was brought in the first place was to stop employers asking that information and making decisions about candidates before they'd even seen them or spoken to them.
Yeah. So actually there's a follow-up question. What about asking, is there anything medical you think it would be helpful for us to know about as part of their induction? But again, I think it's the same point. It's that if somebody has got a medical condition and they want to share it with you because they want you to make adjustments, then that's one thing. But I think if nobody volunteers that information, then you can't know that they need any additional support or adjustment. So, I mean, my feeling is I probably wouldn't go down that route.
I agree. I think that's where the regional adjustments comes in. That's why we ask the questions around the process and what's going to make sure that everyone's on a level playing field about the process itself and the adjustments that need to be made. But it is a minefield if you start asking questions, because then if you're unsuccessful, well, I revealed that information to you, and that's how you based your decision. So
yeah. So this is interesting, actually, Emma, coming back to this discussion around AI. So so that this person has seen a job advert that states candidates shouldn't use AI when completing their application. Is that something that's acceptable to do? I think it probably is, and I think it's probably something we're going to see a lot more.
Charis, was there anything in that you read about around this subject? So I was just thinking that obviously that was your bag, wasn't it, for this?
Yeah, no, I haven't seen anything specifically, but yeah, like Antonia says, I think we'll probably see a bit more of that as it becomes more and more common.
Yes. I mean, I suppose it's difficult. I guess it depends what we mean by AI, doesn't it? Because somebody who has perhaps some disabilities may find that they, for example, they might fill in an application through voice recognition software, and would we say that's using AI to complete the application form? So we probably need to think a bit carefully about how it's worded, into, you know, so that it's what we're meaning is we don't want AI to write your answers for you, to make up the content, but obviously there may be some tools that are used that assist people to complete application forms in a legitimate way.
That's a good point.
So I suspect it's going to be something that we see comes up more and more over the next few years.
Yeah. I think it's really interesting because I know there's lots of articles around at the moment about how you can check something's been drafted by chat GPT and testing it as, you know, in terms of if you were asking it to write an essay. I think that's the thing in the education sector, they're really worried about it, aren't they? Because effectively you can potentially pass your degree by never actually writing an essay yourself. But you know, it's going to be one of those things that we'll see more of as time goes on, and we'll just have to adapt the ways that, and maybe it does mean that we do more face-to-face recruitment and, you know, less focus on written exercises and things like that. I don't know.
Yeah. And just one final question then before we finish, because I'm conscious of timing, but a couple of people, and it comes back to immigration. So what a perfect way to finish the session. But the couple of people had raised this question around what about employees who have temporary right to work and that temporary right expires? Is there then an obligation or a requirement for an employer to then get sponsorship? And I mean, it should be a case that you, in doing the right to work checks, you understand whether it's a permanent or a temporary right to work at the outset, so whether this is going to be an issue or not.
Yeah, I think right to work is a hot topic, and it will continue to be a hot topic. And I think the main message is don't leave it till day one to do the right to work check. Build it into the induction process, build it into the recruitment process so that you understand if somebody has the right to work, and also making sure it's in the contracts of employment, so that if that permission to work in the UK is lost because it's a time limited right to work or otherwise, then businesses have that right to dismiss for some other substantial reason or illegality following fair process. So I think it's more about understanding the information that you've got, using that, and there's certainly not an obligation. You don't have to, there's no business obligation to sponsor somebody that loses the right to work. But it's obviously going to be disruptive for the business if not. What I would say is you've got to be careful not to discriminate and not offer somebody the job because they've got a time limited right to work and they think, well, actually in a year's time or 2 years time we're gonna have problems. So I think it's about building in the right to work check into the process at the right time and using that information responsibly to sort of forecast what's likely to happen.
Great. So I think we've done a good spread across the questions, and conscious of time as well. So Emma, I don't know if you want to have any closing comments.
No, I think it was a really good discussion. I think we've covered a lot of things today, and the questions obviously have covered all those topics. Clearly, everything we've talked about today is hitting home in terms of whether it's recruitment or whether it's the process itself, whether it's AI. I think, you know, certainly all these things, the fitting together are making it more difficult for employers as well. You know, we're worried about our brand and our reputation, but equally we're worried about all the hurdles, and actually our decision making and whether we're going to be challenged on it. But I think a lot of it is preparation and training. That's really key to this, to make sure that we're set up in the best way for the recruitment process, and the people that are involved in that process also know what's required of them, because I think sometimes that's going to be our biggest risk factor in all of this, isn't it? Decision making. So I think, you know, it's been really good today. We've covered a lot of things, and we've had a lot of questions. What we will do is just have a look through any questions we haven't answered, and we'll endeavour to answer any questions separately on the topic. So thank you very much for everybody today. Enjoy the rest of your Tuesday. Hopefully it's warming up and more sunny where you are, because the weather is definitely picking up. I'm feeling the summer vibe. But thank you everyone for today, and we'll see you again soon for the next webinar.